there is a compromise. I keep in my control. So what are the understanding? It's a part of India. 1 and 3 apply. It's an Indian state. But I have a political compromise in which sub-article 1 has how it will operate. That's the compromise. But sub-article 3 is to put the compromise to an end. And I reserve that power. And your lordship will see it from another point of view. There's another point of view. Till the arrangement is in place, unlike other states, where the constitution sets out legislative powers in the 7th schedule in absolute terms. And you need a very elaborate mechanism to tinker with those 7th schedule. It has to be with 50% states voting, etc. Your lordship knows the difference. Here, there was a political agreement, and the whole circumstances, including, as Mr. Anger spells out, the specter of the United Nations, which today is, of course, irrelevant, but at that time was very relevant. The problems in the state. So there was a agreement which is embodied in B, which has concurrence. But if this led to a situation which ultimately prevented the purpose of 370, the purpose of 370 was not to create a permanent divide in the constitution. Lots of material has been shown to your lordship. It was a phased integration. I'm going to deal, Dr. Dhawan has raised a very interesting point of asymmetric federalism, whether that became part of the basic structure. I'm going to deal it separately. But the historical material available to a court, and we have, unlike certain other courts, we have always looked at historical material, especially for articles like this. There was a safety valve in sub-article 3, that if the political compromise in sub-article 1 fails to achieve the purpose, at any time it might become necessary to pull the plug. And sub-article 3 is that plug. Now, if one looks at it that way, the whole thing falls in place. The framers of the Constitution kept with the President the power to do away with this special arrangement. Yes. And history bears testimony to the foresight and wisdom of those, despite the criticism at that time and the political debate which must, in a democracy, you must always have the noise of a democracy, Mr. Bhutto used to say. The noise of the democracy is the most essential element of a democracy. So this has been the subject of debate. But your lordship has seen the entire history of how phase by phase this has been narrowed down. The divide has been narrowed. More and more subjects were added. More and more alignment was brought about. Because the historical perspective of 370 is very important. The troubled relations, while there's always was a hope the relations with the neighboring country would be on good terms, the history of Kashmir did give rise to apprehensions. And the lordship has seen all the material. So border state, with all its sensitivities, is what compelled finally the Constituent Assembly to agree to the special arrangement. But with their wisdom, they said, while you phase it in, you have the power to pull the plug. And this is what I call the contextual interpretation. So the plain language, pure text, and the context.
What is the context, Mr. Salve? How is it distinct from the historical background or the plain text?
The context is that this read by itself, forget the history, this read by itself shows that in sub-article 1, there is a divide in the legislative list base aligned to not the constitutional general 7th schedule, but to an instrument of accession. Broadly, the idea was aligned with the instrument of accession. That's how the powers will be shared. And a partial application of the Constitution of India, not in its entirety, but such other provisions. That's the D. That's the context. With a safety valve in 3. And the history of this provision also tells us it may be difficult to find a logic in each of these because these were a political compromise. Why was the Constituent Assembly put there? That was a compromise. A lot of things are done to assuage ruffled feathers. There were 2 approaches. One was the jackboot saying, doesn't matter, things will settle down. Don't agree to anything special for Kashmir. The other was the other extreme saying, if the legitimacy of the accession is being questioned and there is a popular uprising, accommodate that. This was the compromise. So, one cannot search for too much logic. This was the compromise form. And we must therefore, the safest thing for a court, in my very respectful submission, as a matter of constitutional interpretation of such provisions, And such provisions are essentially political, and I don't mean political in its pejorative sense. I mean it political in its constitutional sense. The court has always said you must give it the widest possible meaning. In fact, my lord, I'll give your lordship that passage. Justice Pandian, in his majority opinion, where he upheld the abolition of the privy purse, where your lordships upheld the abolition of the privy purse, he says that our constitution was meant to be flexible in these areas. I'll give your lordship the exact passage. The fact that the ground realities would change in Jammu and Kashmir and 370 would accommodate was, my lord, first recognized by your lordship in the Makbul Damnu case, which has been cited. Now, two things, my lord, your lordship will note. Applying or disapplying provisions of the constitution.
No, Mr. Salve, I could not get this argument.
Yes. May I just restate the point, my lord? Clause D relates to not 370 but other provisions of the constitution.
Absolutely.
And they can be applied, disapplied, or with such modifications as the president considers appropriate. And that is with the concurrence of that government.
Yes.
Correct, madam? This was meant to operate much beyond the Constituent Assembly also, because that concurrence would continue forever. There would always be a state government. But state government, what that state government is another matter. There would always be a state government. But disapplying 370 was carved out and put in 3. Now that can't be a provision limited in time to the existence of the Constituent Assembly. And that is what explains perhaps why the recommendation rather than concurrence.
Mr. Salve, your voice was cracking just a little bit, when you were making the last part of your argument.
Yes.
Maybe.
I'll repeat it, Marat.
Yeah, if you could.
Disapplying 370 itself comes under subarticle 3.
Right.
And that is why perhaps the framers of the Constitution scaled it down to recommendation instead of concurrence. And that to put it in a proviso that when there is a Constituent Assembly, during the life of the Constituent Assembly, if you decide to modify 370 or disapply 370, because the whole purpose of the Constituent Assembly was to work, to try and find this area of accommodating both.
That's
so if
Mr. Salve, we got your point.
Yeah,
this is a proviso.
Yes.
It uses the word recommendation and it doesn't say if there is a recommendation. We got that point. We got that line of argument.
I was just closing it by saying.
You're making just a little while ago.
Yes.
Was that you began by saying that B1 requires consultation. Matters in the list other than those covered by the IOA requires concurrence. That is B2. Then we went to D.
Yes.
D says, subject to such exceptions and modifications as the President may order by order specify.
Yes.
There is a bifurcation.
Yes.
Matters which refer to the instrument of accession require consultation. Other matters other than those governed by the instrument of accession require concurrence.
Correct. Now, the point which I was making, perhaps that got lost.
We wanted you to just come back again. Yes.
So again, my lord, why this subtlety of instrument of accession being consultation and other than instrument of accession being concurrence, the significance should not be missed. Where it comes to instruments of accession and terms of accession, the last word is with the union.
No, where do you say that? How do you say that?
Because, my lord, instrument of accession requires consultation, not concurrence. The first proviso. Why this dichotomy in the first and second proviso, my lord? And that also, my lord, feeds into my point, therefore, that where it comes to disapplying the 370 completely, because the whole idea of 370 was accommodating the political compromise in the accession.
Mr. Salve.
Yes.
Clause B of 371B does not relate to the power to make adaptations, modifications, or exceptions at all.
Yes.
What 371B says is that of all the items in the 3 lists, the President, the power of Parliament to make laws would be limited by specific matters.
Yes.
So you take the matters in the list as they are, And then you define what would be the domain of Parliament to make the law. There is no power to make exceptions or modifications in Clause B at all.
No, not at all.
Bifurcates. You correctly said that there was a bifurcation. Matters which are referable to the instrument of accession are those on which you only require consultation, because these matters clearly specified in the IOA: defense,
correct,
foreign affairs, communication. Therefore, when Parliament specified the matters on which it would make laws, if those matters were referred to in the IOA, only consultation of the state government was required.
Yes.
Because they were specified in black and white in the IOA.
Correct. But
matters which were not specified in the IOA but are governed by the three lists, concurrence is required.
And my lord,
now when it comes to D, D is not just specification of matters. D is making exceptions or modifications.
That's right.
There again they had a dichotomy. You can make exceptions or modifications, but if it relates to matters in the IOA,
consultation.
Only consultation. So you are really right that insofar as D is concerned, in regard to matters which are specified in the IOA, only consultation is required.
And my lord, one cannot miss the significance, what I wanted to add, of the overlay of the principle of international law, which is engrafted in 363, that these are matters primarily for the sovereign. Instruments of accession and their interpretation has always been a matter for the sovereign. And here the accession being complete, irrevocable and irreversible. That is clear. 1 and 3, Article 1 and 3. Where it touched the instrument of accession, the president had the last word. And that philosophy is reflected in sub-article. That if you want to completely disapply this political arrangement, if there is a constituent assembly, consult them, otherwise you can do it. And there also recommendation.
In other words, Mr. Salve, what you're trying to drive at is that clause 3 of Article 370 is absolutely on the same
philosophy
or is the same platform as clause B1 and the first proviso to D. You're trying to equate the power and the substantive part of clause 3.
The underpinning is the same, my lord. The underpinning is the same.
The first proviso to D and B1.
Yes. And because the underpinning is, this is where we accommodated, or this is where the powers that be, when framing the constitution, accommodated the political compromise in Kashmir. And unsurprisingly, they reserved the power in the president. Instead of driving one to Article 368, they reserved the power in the president to disapply this entire. It's a very unusual provision, my lord. There is no other equivalent where the president is executive government, where the executive government can disapply a provision of the constitution.